looking around. This is a session on hot topics about FERPA and updates. We're not going to talk about the sort of the A to Z of FERPA, but rather some things that have been coming up over the last couple of years and a couple of things that are relatively new just in this last year to talk about. So these are the things. Yeah, that's going to work. So we'll talk about outsourcing, email in particular, but student records in general, as we're all starting to think about moving into the cloud. What are the FERPA implications of that? YouTube. And this is university YouTube. As our faculty start having students use the other YouTube and social media and all sorts of things, lots of FERPA implications there. We'll talk about those rules. Topic of great interest the last year since the Dear Colleague letter came out. How does FERPA intersect with Title IX? Quick preview, nobody knows, but we'll talk about that. Just want to set some low expectations there. Some new guidance that came out just about a year ago from FPCO, the Family Policy Compliance Office, the people in charge of FERPA, about addressing emergencies on campus, and they just slight little nuance changed their approach that they've been following the last couple of years. Big topic over the last, not quite a year now, state longitudinal databases and what FERPA has to say about that. Or more accurately, I guess what I should say is what FERPA used to say about that and no longer cares, but editorial comment. They just put out a new model notice of rights for your students, and I'll talk about that, and hopefully we'll have some time for questions at the end on whatever is hot wherever you come from. So we'll start at the very beginning just to set this up, because I'm not going to talk about all of FERPA, I do need to set up a couple of main points. So the basic framework of FERPA at the college level, it's different at the K through 12 level, but at the college level, college students have 3 basic rights in general. All sorts of nuance to this, and we're not going to go into all that, but in general, students have, at the college level, have the right to do 3 things with respect to their education records. They have a right to control who gets to see them. They have a right to see them themselves, to inspect and review them, and they also have a right to ask us to amend them in certain circumstances. Now, everything we're going to talk about today is in the first one of those, having to do with the controlling the disclosure of their own education records to other people. The big question, however, that all of this raises, and what we need to talk about first, is what the heck's an education record? This is the definition right out of the statute and the regulations. Education records means those records that are 2 things. Number 1, directly related to a student, and number 2, maintained by an educational agency or institution or by someone acting on behalf of one of those things. Seems like a fairly straightforward and simple definition, right? But I'm a lawyer. I will make this more complicated because people have made it more complicated. So in order to understand this definition, we need to understand what some of the words and phrases are. And for purposes of today, I'm going to focus on 3 of them. What is a record? What is directly related? And what is maintained? Those all have their English meanings. They also all have their legal meanings, and we're going to talk about that. So here's the definition of record out of FERPA. A record is any information recorded in any way, not only just words on pieces of paper, handwritten and print records, including but not limited to handwriting, print, computer media, video, audio tape, film. Somewhere in the basement of your library, you may still have microfilm and microfiche. The point being that it is not the medium in which information is recorded, it is the fact that information is recorded. If for some reason on your campus you keep all of your records carved into stone tablets, those would be records as far as FERPA is concerned. It doesn't matter the medium, it matters only that it has been recorded. One exception to that, information that is recorded only in the synapses of your brain is not considered an education record for FERPA purposes. And this is a commonly misunderstood part about FERPA. FERPA is not a statute that deals with information, not generally. FERPA deals with records and information taken from records, but not information generally. Personal knowledge may be regulated by something else, but it is not regulated by FERPA. If you're walking across your campus and you see a student doing something with your own eyes, as far as FERPA is concerned, you can tell the world about that. There may be other implications, but FERPA is not one of them. Very commonly misunderstood, but very important part. FERPA governs records and information from records, period. Next one, what about directly related? Well, in general, a record is directly related to a student if it contains, quote, personally identifiable information about a student. Another definition here. This is intended also to be very broad, just like record. Personally identifiable information includes not only the obvious things like a student's name, address, social security number, campus ID number, email address, phone number, all the things that we typically think of as tied directly to a person, but also any other information that by itself or collectively points to that person. So it could be a bunch of demographic information in a record. It's about a student, you don't know what it is, but it's a male student who's in a particular dorm and belongs to a particular club and comes from a particular hometown. Sooner or later, you're going to have enough information that points to someone. And if you have a record that contains those bits and pieces, that flotsam and jetsam of information about your student in one place, that record would be considered to be personally identifiable to that student because someone on your campus could, without too much trouble, piece it together and figure it out. Again, very broad definition. And the third one we're going to talk about is the word maintained. It might be the most important word in FERPA. Unfortunately, not defined. They didn't tell us what it means. In fact, it became so important that back 10 years ago, the Supreme Court of the United States had to get involved in this wonderful case called Owasso Independent School District versus Falvo. I need to tell you just a little bit about the case. Falvo was Mrs. Falvo, Chris Falvo, I think was her name, and her son, for purposes of today, I'm just going to call him Little Johnny Falvo because I forget what his name was. But Little Johnny went to school in the Owasso Independent School District, where a concept called peer grading was fairly common. So teachers in K through 12 would give quizzes. They would ask the students to exchange them across the aisle, call out the answers. The students would mark them off, and then call out the grades to the teacher, who would write them down in his or her grade book. Little Johnny apparently, this was Owasso Independent School District, not Lake Wobegon School District. He apparently was not above average, and Mrs. Falvo did not like the fact that his grades were being called out to the class and embarrassing little Johnny, and so she did what every red-blooded American mother does nowadays. She made a federal case out of it. And she took it all the way to the United States Supreme Court, where the key issue basically came down to, were the records maintained at the time by the school at the time they were exchanged across the aisle, and some very technical legal issues about whether sixth graders are agents of their institution. And the Supreme Court said, no. But in the course of it, they did have to look at, what does this word maintain mean? What is this FERPA statute all about? And at first, they said, if you read the statute, it sounds like they're talking about this place where every school has this one big room. It looks sort of like that last scene in Raiders of the Lost Ark, and there's file cabinet after file cabinet, and if you pull out a drawer, there's just manila folder after manila folder with names on them, and every record about a student, every record about little Johnny goes into that cabinet. And there's only one person who has the key to the room. It's not Bluebeard the pirate. You won't have your head cut off if you try to get into it, but it's the registrar, right? You all operate that way, right? Supreme Court realized that in fact is what Congress seemed to have been thinking about in this alternative universe when they wrote FERPA. But that's not the way the world works. And so they just said, we're going to look at the dictionary. And what the dictionary says maintain means is to keep in existence or continuance, to preserve, or to retain. Perilously close to, if you have it in your possession, you maintain it. Again, a very broad standard. Now, they did not decide, and this has never been decided by any court or by any FPCO guidance letter that I know of, but I'm pretty sure this is the case. This is my gloss on this. It's not enough that it's physically present, that you have possession, but that someone who really is an agent for your institution has made a conscious decision to keep the record for an institutional purpose. Mere presence itself is, I believe, not enough, for a reason we'll come to in a second when we talk about email. I'll elaborate on that. But again, that's my personal take on this. It's not expressed anywhere in binding law. I'll explain that in a second. So the bottom line is, we have this very broad definition. The subparts are all very broad. And what that means is that, from my perspective, Congress did us a real disservice when it even used the term education records in the first place. Everyone thinks, oh, that means academic, or that's educational, right? In fact, never, at least in my presence, never used the phrase educational records. That is not the FERPA term. It's education records. Really, school records would be far more accurate, because it does not have to have anything to do with education or with academics to be covered by FERPA. Certainly, those kinds of records are covered, transcripts, exams, papers, and so forth, but so is everything else. Advising records, whether that's academic or other advising, financial aid records, the student's financial account, disability accommodation for those students who have them, disciplinary records for those students who have them. Your athletes, their athletic department records are education records. Photographs of your students. Many people don't think about that, but the photographs that you put in your catalogs and so forth, those are actually education records, and FERPA actually regulates whether you can do that or not. I love, people constantly say, oh, we don't treat that as a FERPA record. It's unofficial. I didn't see the word official in that definition, did you? Makes no difference. We have no ability to decide for ourselves what is or is not an education record, and whether it's official or unofficial is essentially totally irrelevant. So virtually everything that we have on our campuses really is, about our students, is an education record. So let's go now to email and start to talk about outsourcing and so forth. Let's walk through the analysis. So is email a record? Absolutely. The definition expressly talks about computer media. Email is a computer medium. So that certainly is covered. Is email directly related to a student? Well, in many cases it is. Many emails will either be to or from a student, and therefore their email addresses will be in the headers. And that's a piece of personally identifiable information that ties the record to a student. Even if it's not between students or with a student, it might be between faculty members or staff members who are talking about a student and who mention the student's name or use an ID number or have enough information in there that people would understand that that record, that email record, is about a particular student. That's certainly covered. Now, not everything in your email system will be one of those two things. And so it's not all there. But the problem is if you want to think about email as a class, you have to assume that some significant chunk of it is an education record. And in particular, if you want to outsource the handling of your email to someone outside, you have to assume that a great chunk of it constitutes education records, because you probably don't want to parse out which ones are and which ones aren't, and just give Google or Microsoft the ones that are okay and keep the ones on your campus. You can't really do that, right? So you have to, when you enter into these relationships, you have to think about FERPA, because some significant chunk of that stuff is covered by FERPA. So the really interesting one, yes?
What if you have a faculty member, for example, who forwards their university email to Gmail or Hotmail or whatever providers, and the student sends personally identifiable information that constitutes a record?
Big problem for exactly the reasons we're going to talk about here. That analysis is really no different than if the institution outsources the entire email thing. So the problem is you can't control that. And I know that it happens. You may want to, in fact, prohibit that for FERPA reasons and warn people that they may be violating FERPA and other things. I mean, all that outsourcing, if you have a faculty member who's engaged in research and is forwarding email to Google, they could be losing patents, all sorts of reasons not to do that. But the key one here, maintained. So is email maintained by the institution? Here, I think you have to, going back to that conscious decision thing, I have to draw a distinction between email that resides in student email boxes, might be their own email or might be something we've sent them, but it's sitting in their email box. And that's different from email that is sitting in a faculty or staff mailbox. In both cases, we are maintaining the server on which that email sits. But I don't believe in the case of student email, that means that we are maintaining the student email. We don't care whether the students keep their email or not. We've made no decision to keep it or not. We have simply made a space available for them to keep their property or not as they choose. Who cares? It's up to them. If that's all that it takes to be maintained for FERPA purposes, the logical implications are absurd. That means we can no longer have bulletin boards on our campuses, because as soon as students post something to the bulletin board that we own, we must be maintaining it, right? We have to take it down. It's being disclosed. We cannot allow students to have whiteboards on their dorm room doors. As soon as they write something, we would have to take it down. That would become an education record. If we have lockers, or if we have shelves in our dorm rooms, as soon as a student puts a notebook on it, that becomes an education record. That can't be the case. We don't care. We are maintaining the physical environment, but we are not maintaining the record for student email, my take. And so it's actually, I believe, quite easy to outsource the handling of student email. However, with faculty and staff email, we are maintaining not only the box that it sits on, but there is someone who is an institutional agent who is deciding whether or not to keep that email. So it's not just the physical space, but someone is keeping the record. And that, I believe, is, if it falls in one of those first two categories, is an education record. And there are implications, therefore, for what you can do with it in terms of outsourcing it to a Gmail or Microsoft or somebody else. So let's talk about the rules about outsourcing. FERPA allows outsourcing. We can outsource the handling of student records, and not just email. Any student record can be outsourced, the handling of it, to contractors, consultants, volunteers, anybody we want, as long as three things are true. By the way, in doing that, essentially we're designating them as, quote, school officials. And we're not going to go into that, but there is an exception in FERPA that allows you to share information with other school officials who have a job-related need to know. So you can designate this outsourced, the contractor, to be a school official, and they can handle student records as long as these three things are true. First of all, they're performing a service that you would perform yourself. You can't, for example, go to a credit card company and say, we'll sell you all the student information and you can market credit cards and we get a royalty. We're not in the business of doing credit cards. We are, however, in the business of doing email. And we can do it on campus, and as far as FERPA is concerned, we can do it off campus if we want, because we can just take that chunk of service and outsource it. Now, the outside contractor also has to be under our direct control. Not generally. They can be independent contractors under legal standards. They don't have to be actual employees. But they have to be under our direct control with respect to how they handle the records. We have to be able to tell them, stop doing that, and so forth. And the most important one is the third one. They have to understand that they are standing in our shoes with respect to FERPA. If we couldn't do something, they can't do it. If we could do something, they can do it. And that means not only in terms of redisclosing the records to others, but also using those records. They can use them only for the purposes for which we would have used them, not for their own benefit, only for our benefit. Now, in order to do that, as I said, we designate folks as school officials, and we have to ensure, this is the direct control part, that they do not maintain, use, or redisclose the records except as directed by us. We have to have that control in terms of what they do. They do not get to use it for their own purposes. One way you can do that, this is interesting, it says one way, it's not an absolute requirement. One way you can do that is by having a contract with them that outlines their responsibilities under FERPA, clearly describing those responsibilities in a written agreement or contract. For anything at all formal or major, I would never do it without a contract, but it's interesting that it's actually not required in all cases that you have a contract. If you're doing email, it's a big undertaking. You're going to want a written contract. In fact, you're going to have to, because they're going to give you one, and then you're going to have to try to negotiate it because it will not be what you want. Come to my presentation about contracts tomorrow. We'll talk about that. What about outsourcing to the cloud in particular? A lot of people say, oh, that's just all these issues. We can't really do that, right? Well, no, FERPA, there's nothing in FERPA, this is guidance from FBCO, there's nothing in FERPA that says, as a class, the cloud is a problem and you cannot outsource handling of records to people in the cloud. That's fine. You have an obligation to use reasonable methods to make sure there's appropriate security. That's a new thing. We were talking about privacy a moment before. You have to make sure there is reasonable security as well as the privacy issues. But as long as you do that, it's fine to outsource to the cloud. When you do that, include any kind of services, web-based, email services, that's fine. But make clear again in your contracts that the outside party may not use or allow access to person identifiable information except in accordance with the requirements that you set. This is the key to outsourcing, and this is the problem with outsourcing, or at least has been the problem for many years in terms of outsourcing email, because the big vendors, they want to use our email for their own purposes. They want to be able to data mine it and serve up ads and so forth based on that. That is not something we would do. It is not for our benefit, and that's a problem under FERPA. Sending it around to wherever it's supposed to go is fine, but using it for their own purposes is not okay. So let's take a look at an example. And I don't mean to pick on Google. I picked them only because I did that. This is the contract that I negotiated. They're not particularly better or worse than any of the other vendors. And this is a good example of really what we always go through in outsourcing any kind of stuff to the cloud. It's not fun. And your lawyers go through lots and lots of negotiations with them. So if you go to Google for Google Apps, they have this lovely page about security and privacy. It's a technology platform that schools can trust. And it says nice things like, Google complies with applicable privacy law. And the Google Apps Terms of Service, your contract can specifically detail our obligations in compliance with FERPA regulations. Now that word can is interesting to me. Sure it can, anything can. Why doesn't it say it will? That's sort of interesting. Well, 4 years ago when I started first negotiating with Google, I found out why. Because they desperately did not want to comply with FERPA. In fact, they told me when the negotiations about 4 years ago, it took me about 6 months to get to a lawyer, and I finally got to the lawyer and was explaining why we were doing student email at the time, which is fine, but we were reluctant to do the faculty and staff, and many other institutions were because of FERPA. And he said, well, FERPA doesn't apply to us. I said, I know it doesn't apply to you, but it does apply to our records, and if we give you our records, it carries with you. And he said, oh, you don't understand FERPA. We have a problem here. This is what they now say. If you go to their current contract, it actually does say, hopefully, here we go. This is now in their standard contract. The parties acknowledge that customer data may include person identifiable information from education records that are subject to FERPA. And B, to the extent that's true, we will be considered a, quote, school official, as that term is used in FERPA, and will comply with FERPA. That sounds pretty good. I'm just not 100% convinced that their understanding of FERPA and my understanding of FERPA are exactly the same. And again, I'm not picking on Google. I think this is true of all of them. Back to that website, this is what they say about privacy and their privacy policy. Is your content, not ours. Belongs to you and the individuals, not Google. That sounds good. We don't look at your content. Google employees will only access content that you store on apps when an administrator from your domain grants them explicit permission to do so for troubleshooting. Well, that's probably OK, too, because we do troubleshooting and sometimes have to look at things. We don't share your content. We don't share personal information with advertisers or other third parties without your consent. Well, that's good. We wouldn't do that either. We sometimes scan content, and for very good reasons, like spam filtering, antivirus protection, or malware detection. We scan content to make apps work better for users, enabling unique functionality like powerful search in Gmail, Google Docs. Completely automated, and it involves no humans. Well, that makes me very happy. I have never been able to get Google to definitively say that this means they do not data mine. They say, oh, but we don't serve ads in your email. I get that. Do you data mine my email and connect the cookie up to the cookie over on this service and send ads over there based on that? I've never gotten that answer. Maybe they do it, maybe they don't. I don't know. But that would be a FERPA issue if they did. And it seems to me that they are rather coy in trying to avoid that. Also, there's a few common sense exceptions to the above. There are always holes here that disconcern me when you're dealing with these sorts of things. Now, about a year and a half or so ago, many of you may have found that Google redid its entire infrastructure, its architecture, and came up with a lot of new services that could be available through Google Apps if you wanted. And the form contract says if you want to do those, you have to go to the additional terms of service for those. And you can go, when you click on that, the additional terms, it takes you to the new agreement for those, which is totally separate from the one you've just negotiated for email. And it says those services are not subject to your Google Apps. Whatever you negotiated there is irrelevant. You have to go to the terms for each individual service. And they have, I don't know, 60 or 75 now. So you can go and you can click through if you want. It'd be lots of fun. Read through all the terms for all the different services. Back to the main contract, it says, FERPA is now up to you. We make no promises whatever with FERPA. If you think this doesn't comply with FERPA, stop using it. That's helpful. And my favorite term, the last term, Google, this contract is meaningless. We can change it whenever we want. These unilaterally change the terms whenever we want. To me, that's a bit of a FERPA problem. Your mileage may vary. This is the sort of stuff we negotiate. It is a legitimate problem we have to deal with doing it. There are other forms out there. This is one from Catholic University of America, sort of a contract writer, not just for email, but for any time you're outsourcing electronic student information. You can find lots of these kinds of forms that have things that are written from our perspective and not from whoever the vendor's perspective may be. So I commend that you, as you're negotiating these contracts, think about these kinds of things if you can do it. It's hard to get, the bigger the company, the Microsofts and the Googles, hard to get them to bend. So switch gears to the next electronic thing, which is YouTube. Is it okay under FERPA if our faculty want to require their students to participate in listservs for some educational reason? Is it okay if they want to require the students to post to blogs, to create a portfolio and put it out online? At RISD, where I am now, that's a big thing, portfolios. To create a video and post it somewhere to the other YouTube or somewhere on the web. To use any kind of social media. What does FERPA have to say about this? Well, this is just, we're talking about posting academic stuff online. There must be some FERPA implications. Does it matter in terms of that whether the server where this stuff is hosted is on your campus or one of those commercial services off-site? That may actually make some difference. And does it matter whether that site is open to the public or only available to students in that particular classroom, electronic or otherwise? All three. Some preliminary things about FERPA to understand. First of all, you have to understand FERPA applies only to educational institutions. It does not apply. Google was right when they told me it doesn't apply to them, not directly. They have no obligations under FERPA, and they're free to interact with students one-on-one and have no FERPA implications. It also does not apply to the students themselves. Students are free to disclose their information to whoever they want, whenever they want. FERPA doesn't regulate that. It regulates what we do with those things. So at least as far as FERPA is concerned, if a student wants to go out and post something to YouTube or social media, not an issue. They're free to do that. And YouTube or Google or whoever is also free to do that as long as the connection is straight from the student to Google. I think, and again, this is my speculation, I think our faculty probably could require students to go out and to directly post things to the external web. Again, the transaction is, it's required, but student to Google or YouTube is not an institutional transaction. We're not disclosing anything. Probably okay, but the real interesting question is, can they require students to post things to internal websites, which may or may not be publicly available? Those are our websites. We control them, our servers, our whatever social media, if we have our own blogs. And so it's not dealing with an outside entity, it's dealing with us. We now have an obligation under FERPA to deal with that record. And can our faculty post our student information themselves to the external media? In either case, we're now involved in that transaction directly, so there are some FERPA implications. Now, there is no law on this. Yes?
Now, what about directory information? If a student restricts their private or their information and they don't want to be publicly identified as either being part of a class or otherwise, and the faculty member is requiring them to post to an external source, isn't that a workaround?
Hold that thought. That's a very good segue in about 2 slides, I think. You're thinking on exactly the right lines here. So there is no law on this, so I have my implied pedagogical theory exception of FERPA here. And I believe this to be true. Over the last 20 years, the Family Policy Compliance Office, in a number of circumstances, has done things that clearly violate, or authorize people to do things that clearly violate the literal language of FERPA. But in cases where it's just so much part of our traditional pedagogy, there's a good reason for it that they're saying we're not going to get in the way of that. So the first one goes back, I think, at least 20 years ago, where they said, you know, it's okay to put theses and dissertations of your students on your library shelves. Well, that's a disclosure of a student education record. How could that possibly be the case? They said, don't worry about it. Okay? Basically, they said it's a traditional part of the pedagogy, and as long as your students understand that that's going to be part of the required curriculum, that's fine. They're not going to get in the way of, you know, FERPA now means that we can no longer disseminate the corpus of knowledge that we're producing. That would just so fundamentally change American higher education. They were not going to impose that. There is nothing in FERPA that authorized them to say that. Clearly violates the letter of FERPA. We're disclosing education records without written consent of our students. Can't do it. But they said it's okay. So that's one piece. Sorted to yours. In 2008, they came out with some new regulations that took effect in 2009, and buried in there, among a lot of other things, was this very interesting thing that says that although students have the right to opt out of directory information, not to have their names disclosed even in your directories, that does not extend to the classroom. There is no right to be anonymous in the classroom. It's perfectly fine to have a class roster and to call out students' names, and make them answer questions, even if they've opted out of directory information. And that's true even in the electronic classrooms where it's all done online, which means there's actually an electronic record. You can require your students to identify themselves in the online classroom by name or email address or whatever, even if they have opted out of directory information. There's no right under FERPA to be anonymous in class. Well, actually, yes, there is. Literally, that's what FERPA says. There is a right to be anonymous in class. I'm convinced that this came up. Some law student said, I don't want to be subjected to the Socratic method. Make him stop. And they said, nice try, not going there. I mean, participation in class, knowing who your fellow students are, having discourse back and forth is just a fundamental part of pedagogy. We're not going to stand in the way. So basically, they said, just don't worry about it. More recently, in some regulations that came out at the end of last year and took effect, I think, in January of this year, they extended that a little further to say it's also okay, even for students who have opted out of directory information, to make them wear a name badge for security purposes on your campus. You're requiring students to disclose information that they don't want to disclose, but tough. Don't worry about it. Again, literally, that violates FERPA. They said that's okay. And then what may be the most significant one is back in that Owasso case that I was talking about, the Supreme Court, as they went through this, they said, we just can't believe. The Court of Appeals, which had ruled the other way, their interpretation of FERPA, under their interpretation, the federal power would exercise minute control over specific teaching methods and instructional dynamics in classrooms throughout the country. The Congress is not likely to have mandated this result, and we do not interpret the statute to require it. I mean, very common sense sort of thing here. FERPA was never intended to interfere with pedagogy. It's about protecting our records for the outside world. And if there's something that's, in my view, if there's something that's really a fundamental part of our pedagogy, especially if it's been a traditional part, or there's an analogy to it for a traditional part, it's probably going to be okay under FERPA, even if you run into some literal issue of FERPA. Again, this is by theory. This is not legal advice, but take it for what it's worth. So, next question we need to ask. I believe that it probably is okay legally for faculty to require our students to post things to outside websites, to post them to internal websites, to post them themselves to outside websites, even if they're accessible to the general public, if there's a good pedagogical reason for it. But the fact that it may not violate FERPA is not the end of the story. There are many questions there. You should ask not only may I do something, or not only can I do something, the technical question, but may I legally, and should I? And there are a lot of questions that people should be thinking about. We shouldn't be rushing out to do these things just because it's the shiny new toy, which happens a lot. We should do it because there really is a good pedagogical reason. And not only a good pedagogical reason, but we've thought about some other questions. What is the pedagogical reason? First of all, if there is a pedagogical reason for the posting, is there a reason why it should be to the public? Might be. At RISD, for example, our film, animation, and video students, they make films. And during the course of the semester, we call them critiques, where they show their stuff to their fellow students and they talk about them, which is where much of the learning goes on. Crits is a very important part of things for art students. At the end of the semester, we have a public show. The public can come watch them. I believe that's also an important part of the pedagogy because you learn a lot as an artist, not just probably what your fellow artists think about your work, but also what the public, how they react to the work. Well, why not post it to YouTube? There could be a good pedagogical reason for that, for making your work public. Most of our students would be delighted to do that, but even if they didn't want to, that could be a good pedagogical reason for doing that. If it is going to be posted, though, does it have to be the general public or not is one question to ask. If there is a good reason to post it publicly, is it important, and I think this is your question, that it be attributed? It might be perfectly fine to have the work exposed where it can be commented on, but without a name. A student might have a reason to want to have privacy, and is there any reason that you need to override that? Maybe there is, maybe there isn't. But think about that. What are the implications for the student's privacy? If your student made an intensely personal film about their personal life and there's a stalker out there, do you really want to get into that? Think about those kinds of things. What are the implications for the student's intellectual property? Posting something to the internet does not mean you have given up your copyright to that work. It just means it's now publicly available. But it does mean it's a lot easier to rip off, right-click copy, it's mine. Not legally, but I have a copy. If it, again, we talked about patent a minute ago, if it's a patentable invention, it may mean that the clock, the one-year clock for getting something filed has started to run because we now have public disclosure. Has anybody thought about those kinds of things? I don't care what the answer is. I care that you think about those things. And probably from my perspective as a lawyer is before you do that, has anyone actually read the contracts and terms of service? Do you know what it is you're requiring your students to do, that, you know, that they've now given up their firstborn son to Googlesoft? Whatever it says, someone ought to be thinking about those things because those terms of service are fundamentally one-sided. And if you haven't thought about that, you may be doing something that really disadvantages your student in some way. If you think through all these things and you come to the conclusion we still should do it, fine, I'm behind you. I just want you to think through those things. FERPA and Title IX, switching gear again. In the last, I guess about a year and a half since the Dear Colleague letter came out, which I know all of you know about and are just really big fans of, and have been dealing with on your campuses for the last year. One of the questions is, what the heck does this mean for FERPA? Because there's all sorts of things they say in there about how our disciplinary systems have to run that sure don't seem very consistent with FERPA. And not only the disciplinary system, but the preliminary investigations and so forth. As I said, the preview at the beginning, I don't know the answer either. I'm not sure that anybody knows the answer. We're making this up as we go along, including the folks at the Department of Education. It's sort of all in flux. But here are the pieces that they have said so far. So the fundamental part, in the actual FERPA regulations, it says this: if an education record of a student contains information on more than one student, a student who wants to inspect and review his or her own education records gets to see only the part that deals with that student. And if there's information about other students, you have to redact it out. And what they used to say was, if it's impossible to redact out the information about the other student, put the thumb in the scale on the side of privacy. The student who wants to see information can't see anything. We're going to protect the other student's privacy. The Dear Colleague letter does not quite agree with that. They say the alleged harasser may have, this part is close to that. The alleged harasser may have a right to inspect and review the portions of the complaint that directly relate to him or her. In that case, the school must redact the complainant's name and any other identifying information. In this particular kind of situation, you can't redact anything without disclosing something about the other student. So they appear to be, that earlier thing about the thumb in the scale and privacy has now perhaps switched a little bit. They do get to see only the parts that relate to him or her, but what are those parts? In particular, after this thing, the 2008 regulations I mentioned a moment ago had this particular quote. Had nothing to do with Title IX at the time, but it was, I believe, an effort to try to address the issues of FERPA in our disciplinary systems, and in particular how FERPA and due process were sort of clashing. If a student can't see the information that the complaint is based on, how does he or she defend himself adequately? There's a due process issue there. And so the most recent thing they said was, you have a right to inspect and review any witness statement directly related to you, even if the statement also contains information that is also directly related to the other student, if the information can't be segregated and redacted without destroying its meaning, if it's inextricably intertwined, which is always going to be the case in terms of complaints and so forth. For example, both John and Michael would have a right to inspect and review the following information in a witness statement. John grabbed Michael's backpack and hit him over the head with it. They were talking about K through 12, I think. But they sort of reversed course a little bit so that when it's in this due process sort of situation, you do get to see the inextricably intertwined information, even though you're seeing information about another student. And that seems kind of fair. It is hard to defend yourself without that. Well, we go on. So DCL says the complainant and the alleged perpetrator must be afforded similar and similarly timely access to any information that will be used at the hearing. For example, a school should not allow the alleged perpetrator to review the complainant's statement without also allowing the complainant to review the alleged perpetrator's statement. Now, probably, they're both inextricably intertwined information, but it's not entirely clear. So we're veering into sort of some FERPA unknowns here when they get into that. Again, as a fairness matter, I can't say it's unfair, but the statutes just don't neatly align on this. long sort of statement. We recognize there may be confusion. What you can disclose to the complainant. Generally, you can't do that. However, in terms of a sanction, they said, back all the way in 2001, they said when the sanctions come out, you can disclose to the complainant the portions of the sanction that relate to him or her. So if, for example, there's a no contact order, you can tell the complainant there's a no contact order, so he or she can enforce it. But if there are other things, a fine or something, the student wouldn't get to see that. I'm not entirely sure if that's still the case, although that's in the DCL. There seems to be much more information sharing here, and particularly since they have to have the simultaneous and equal rights of appeal, kind of hard to know what to appeal if you don't know what the sanctions were. And then the final statement they have here, I think this was actually in a footnote, where they basically have said if there's any confusion, any conflict, Title IX wins. That apparently is the current view of the Department of Education. In 1994, when they amended the portion of law that Title IX was in, we said that it wouldn't be construed to affect, nothing else in that statute would be construed to affect the applicability of Title IX. And so we interpret that to mean that, in effect, Title IX trumps FERPA to the extent of a conflict. I don't know how far they will play that out. I don't know if they will play that out. This really is sort of getting made up as questions come along. But that is the best I can tell you right now about the status of Title IX versus FERPA. It's a mess, but Title IX seems to have the thumb on the scale in that area. Switching gears again. Now, emergencies on campus. The so-called health and safety emergency exception has been around for a long time, but the pendulum on what it means has swung back and forth. After 9/11, for example, they started to ratchet down as the FBI was coming on to many campuses. I dealt with this, I'm sure many of you did. The FBI was coming on to many campuses and saying, we want to know everything about all of your Middle Eastern students. And it's a health and safety emergency under FERPA. Probably not really. And there certainly were issues and information that could be shared, but just sort of a wholesale blanket opening up the files of every Middle Eastern student was really not where we probably should have been. It was an overreaction. At the time, they sort of clamped down on the health and safety emergency exception, and for many years, people believed that it had to be, true crisis. The bullets were flying on your campus before you could do anything under this exception, which actually was never the case, but that was sort of the impression they gave. After Virginia Tech, they considerably opened it up, and they said, no, you need to focus on this. And actually, we don't even use the word emergency. What we're talking about in the statute is a threat to health and safety. If there is a threat to health and safety, you can disclose appropriate information to appropriate parties. If knowledge of that information is necessary to protect the health and safety of the student or other individuals. And they were pretty good. Who are the appropriate parties? Well, law enforcement certainly would be part of that, but not the only part. It also could include lots of other people, your threat assessment team, which would be a school official anyway. People who may have information that could assist. You go out and talk to roommates and students and other people who may be interacting with this person to gather information and probably disclosing something in the midst of that. To the extent your mental health professionals have seen the student and their own mental health standards allow them to release information, that would be an appropriate person to talk to. And you can always tell them information if you think they need it. Prior school attended and so forth. The potential victims, yeah, talk to them. Mom and dad, lots of people. They said, you can open this up a lot of people. And you shouldn't be afraid. It's a threat to health and safety, not the actual emergency underway on your campus. Well, now, after a few years of experience with that, I think they're starting to see some overreaching where people are probably disclosing more than they should. And a year ago, June, they came out with some new guidance where the pendulum is just slightly coming back toward the middle. And they now are saying this. Disclosures for health and safety, emergency reasons do not include disclosures to address emergencies for which the likelihood of occurrence is unknown. Can't just be a vague, uneasy feeling you have. Such certainly would be the case in emergency preparedness activities. That's just planning stuff. Rather, disclosures under this exception must be, quote, in connection with an emergency, which means it must be related to an actual, impending, or imminent emergency. We've ratcheted it up just a little bit more, such as a natural disaster, a terrorist attack, a campus shooting, or the outbreak of an epidemic disease. They're also ratcheting up perhaps just a little bit what the kind of emergency is. Before, it seemed to be a little more free-floating standard, and things that were not quite that level of emergency, you probably could disclose, at least to some body of people. When you do that, you have to do it on a case-by-case basis, which was always true, facts and circumstances that are known. Now, before when they said this in 2008, they made a point of saying, and we also know that you don't know all the facts and circumstances at the time you're making the decision. And that sort of fell out of here, which is a little bit ominous to me, but I think it is still the case. They do not want to Monday morning quarterback you, and they don't want to come in and say you have to wait until you know all the facts before you can make decisions, because obviously that would be too late. But they're just ratcheting back a little bit. But this sentence is still in there, and it was in the 2008 regulations, and this is the very important one we all still can rely on. It's a flexible standard under which the department defers to school administrators so that they may bring appropriate resources to bear on the situation, provided that there is a rational basis for your decision. Rational basis about the nature of the emergency and the appropriate parties to whom the information should be disclosed. Those of you who are lawyers, or those of you who have lawyers on your campus, lawyers love the phrase rational basis. We can drive many convoys of trucks through that phrase. You do not have to worry unduly that I have to wait until the gun is pointed before I can disclose something. As long as you have a good faith belief that there is a threat, and it's not something minor and inconsequential, but there is a threat, and you make some rational basis about who you're disclosing it to. You're not just buying a full-page ad in the New York Times and throwing out somebody's transcript just for the heck of it, but talking to police and other things. You're going to be okay. You're going to have a good argument here. So don't worry unduly about this, but just be aware that for whatever reason, I think they do seem to think they're seeing a little overreaching now. So be a little more careful maybe than we were before. Also, when you're dealing with emergencies, just keep in mind there are many exceptions besides the threat to health and safety exception. We talked about personal knowledge. FERPA doesn't regulate personal knowledge. Anybody who's seen something is free to talk about it. There are exceptions for law enforcement unit records, the records that are maintained by your police or your campus public safety. In many cases, are free of the FERPA restrictions, and they can be talking to people. There are exceptions for disciplinary records. After someone has been found in violation of something that would constitute a crime of violence in a court, you are free to disclose to the world that the student was found in violation of that provision, who the student was, what the provision was, and what the sanctions were. Not other stuff, but that much information. Many ways that you can talk to mom and dad, even if it's not a health and safety emergency, with consent, if the student's a tax dependent. Judicial orders and subpoenas. You can always hint to your local prosecutor, we have this issue you might want to look into. Could you crank up the word processor and give me a subpoena? I'd be happy to give you this information. If they have a subpoena, you have to comply with that. And you also are perfectly free to share whatever information you have with your threat assessment team on your campus, because unless you have a bizarre definition of who a school official is, they're going to qualify. And they're the ones who can help you determine whether there should be broader disclosure. So lots and lots of ways to deal with this. Nothing to worry about a lot, but just be aware that slight change in nuance. So here's the big one over the last year. Yes?
You mentioned threat assessment meetings. Is information discussed in those meetings covered under FERPA?
Yes, it is an education record, and the student would have a right to inspect and review it. So be very careful how you write things.
Do you recommend you talk about personal knowledge? Notes, or if you do take notes, could it be considered?
The individual notes conceivably could fall in another exception we didn't talk about for sole possession records. As long as they're not shared with anyone else, not accessible to anyone else. And that may be one thing that people have their own individual notes. That doesn't mean they're not subject to a subpoena if there's a lawsuit, but at least the student doesn't have a right to come in and demand them. You are going to have some record, though, because you just need a record of what you have done. So the best thing to do is make sure whoever is writing that record knows how to write a record and is appropriately cautious, not inflammatory language. Oh my God, this kid's a nightmare, we have to get him out of here, but talks about the facts and circumstances and outlines them. The other thing, this is perhaps the most important thing, is if the student does make an inspection review request, you have 45 days to respond. And you are perfectly free to take exactly 45 days to the second. It's not like a public records statute where you have to drop everything because the world is on fire. You can take 45 days. And in 45 days, you can do a lot of stuff to deal with whatever the issue is. So that's probably the ultimate answer. State longitudinal database systems. Washington, since President Bush and now under President Obama, they have been doing everything they can to create these state longitudinal database systems for purposes of educational accountability and tracking people and so forth. And you can debate the philosophy of that. I have my own quibbles, but it's a philosophy matter. But there is a FERPA issue here that up until recently had not really been dealt with. Now the Department of Education says, oh no, we are safeguarding student privacy, and they put out all sorts of things about this as they talk about it. Interestingly, the first line of something talking about safeguarding student privacy is how important it is to use data about students. I might just, if I were really talking about privacy, I might have had a different thesis statement, but whatever. Here's what FERPA says about that. There are two exceptions that are relevant. One allows sharing of information to authorized representatives of state and local educational authorities in connection with an audit or evaluation of federal or state-supported education programs. And the other is that schools can disclose student education records to outside entities, outside organizations who want to conduct studies, either to develop, validate, or administer predictive tests, to administer student financial aid programs, or to improve instructions. So we could, sort of data mine our own information to see if what we were doing was okay. And for a very long time, the Family Policy Compliance Office said, this means you cannot do state longitudinal database systems, if by that you mean unit records that track people from K through 12 into the workforce and beyond. You can actually get information into those systems possibly, but getting it back out, FERPA created all sorts of restrictions for getting it back out because privacy is important, and we want to make sure that the student information didn't get inadequately disclosed, or improperly disclosed. Well, there's been a big push for that, against that over the last few years, and the side that has been pushing for it finally won. And so now they have amended things. They actually haven't amended a word in the regulations, but they have now defined many of the words in the regulations. So all these different things we're going to talk about here. So what is a state and local educational agency or authority, first of all? They said, well, we traditionally have interpreted that to mean things like state post-secondary commissions, Bureau of Indian Education, any entity that's responsible for and authorized under statutory law to supervise, plan, coordinate education programs. And we all kind of know who that is, I think. But no longer does it mean that. Anybody else could also, any other agency, a state social services agency, maybe a Department of Labor, they're all fine. Could, depending on the individual circumstances, be considered an educational agency or institution, or a state educational authority under FERPA. So we've just opened up that door now, quite broadly. What about authorized representative? We always had understood authorized representative to be, the people who work for that SEA. Well, now it means anybody that the SEA designates to be their representative, any person or any entity. And that does not necessarily mean somebody who works for the agency. That would, we want them to have flexibility and discretion to determine who would be best able to represent them in connection with audits and evaluations. Restricting them only to their own employees, well, nothing in the dictionary that would require that. So we can now fling those doors open as well. And yes, we agree. In fact, we want this to be the case, that this will increase the ability of FERPA-permitted entities to conduct audits or evaluations of programs, including those that link person-identifiable information from education, the education sector across into the workforce sector. That's what this is all about, and it's now, okay, those can be authorized entities, representatives. Now, don't worry, we're not, we know Congress told us 10 years ago that we can't create at the national level a unit record database system about our students. We're not trying to do that. I have no interest whatsoever in doing that. But the states can do that if they want. Wink, wink, nudge, nudge. And if they want to link those across state lines, well, there's nothing in FERPA that would stop them from doing that either. In fact, FERPA doesn't talk about geography. Geography is irrelevant. We don't care about international lines either. This is getting interesting. What about the term audit and evaluation? Surely that must mean something, right? Well, they're not defined in FERPA, and we're not going to define them either because that would constrain people too much. We don't wish to define them in ways that would unnecessarily restrict the educational community. So whatever you think is an audit or evaluation is probably good enough. What about the authority for that? Well, it used to be the authority for that had to be specified in a statute or an ordinance or somewhere. Well, that's still fine, but implied authority is fine with us too. If you sort of think you might have authority, that's okay. What about education program? We know what that means, right? Well, any program that is principally engaged in the provision of education, including but not limited to early childhood education, elementary and secondary, post-secondary education, special education, job training, career and technical education, adult education, any program at all that's administered by an educational agency or institution. So if we run it, it's in educational programs. So things like bullying prevention programs, cybersecurity education, substance abuse, violence prevention, all those are educational programs. We can link all this information together. Also, stuff by other people would regardless of where or by whom they're administered, would fall into the definition of education program. Educational programs conducted by correctional and juvenile justice facilities or alternative long-term facilities such as hospitals, dropout prevention and recovery programs, after-school programs dedicated to enhancing the academic achievement of its enrollees, schools for the hearing and visually impaired, college test tutoring services, high school equivalency programs. Everything is education. We can link all this stuff together. What about the conducting studies? Well, we could always do that. And now so can, once the information gets into the state longitudinal database, they can do that too because they're authorized. And they can do that if two things are true. First of all, they have to have authority to do so. Again, that can be implied authority. And also, you either have to agree to the disclosure, in which case that study is done for you, or if you object to it, they can do it anyway, and they do it on your behalf. Oh, that's nice. You can't stop them. Once the information is away from you, you have no further control over it. The goal here is, as one person I heard talking about this said, the goal here is to create a database that tracks people from pre-birth through death. Literally. Now, there are valid educational reasons to do that. I have some disagreement on the philosophy. But what concerns me about this is they've paid very little attention to the security side of this. And so when Lenny from Law & Order comes in with a subpoena for that information, are you going to give it to him? I mean, who knew that E-ZPass records were so great in murder cases? Well, someone's going to figure out a reason for this for something other than education. What are you going to do about that? They don't want to think about that. What's going to happen when you have the data breach? We don't want to think about that. When the IRS comes in and wants to track somebody because we track them through all sorts of other ways, this would be good too. You don't want to think about that. They do, however, they do say that you have to have a written agreement with the people you disclose the information to. And you must use reasonable methods to ensure to the greatest extent practicable that FERPA is complied with by those other people. They can do whatever they want with it, but comply with FERPA. However, while we agree that written agreements are important, we're not going to tell you what to put into them. That would unnecessarily constrain your flexibility. You should have substantial flexibility to do this, not a one-size-fits-all solution, and I agree with that in concept. The only thing we will tell you is that if you have a written agreement that doesn't give any restriction whatsoever, that's a problem. So one restriction, maybe you're okay. I don't know. They don't go very much beyond that. On data security, they also said security is important, but we're not going to tell you what to do there either. You have to have flexibility based on your individual circumstances. They do, however, and this is actually not bad, they do have some guidance for reasonable methods. And if you read through this, there are some pretty good thoughts about how you would go about restricting this kind of stuff. But the goal here clearly is not to be overly restrictive from their perspective. They want to facilitate this for the educational accountability reasons. Now, one last thing about this thing. One thing to understand about this exception, these two exceptions under FERPA, and about every exception under FERPA is that they give you as an educational institution the ability, but not the obligation to disclose records. There is nothing in FERPA that requires you to share information with a state longitudinal database system. FERPA is agnostic on that issue. It simply now has thrown up the door to allow you to do so. You may disclose information, but not must. However, states are perfectly free to require institutions to do things that are not prohibited by FERPA. And so one of the things that I expect we are going to be seeing, probably some of you already are seeing, are your states are requiring either as a condition of state money or just as a mandate, you need to collect and give us this information, and FERPA will not stop that. At this point, FERPA will not stop that, so stay tuned on that issue. One last thing, and then we'll break for questions. This came out, I think, sometime earlier this year. After they did all these regulatory amendments, they amended their model notification to students. One of the requirements under FERPA is we have to notify our students annually of their basic rights under FERPA, those 3 rights: to control the disclosure, to inspect and review, and to seek amendment. And they have long had on their website, and this is one of the handouts in your packet, they've long had on their website a model notice that we can pretty much cut and paste from the word processor that does that. Tailor it if you wish for your institution, but you can do that. It was a 1-page form. They now have expanded that to I think a 2 or maybe 3-page form. And they've done 2 things. One is they slightly revised the description of who can qualify as a school official. I'm not sure there's any truly substantive difference there, but it's probably worth looking and just using their language because they said it's okay. But the other thing they've done is, if you wish, you can disclose not only those basic rights, but you can have a brief description of all the various exceptions under FERPA that allow the non-consensual disclosure. I think there are 16 or 17 currently. And they've got bullet points, every one of those things listed. Might be interesting for your students. I don't know if anybody actually reads this, but if you're inclined, you are free to adopt that. You're not required to adopt that, but it's, now that they've issued that, probably a good reason to just go out and make sure your annual notice is actually, that you have one, and see if it's the shape you want.